Well, good afternoon, and welcome to this week's presentation by Beresford Booth. I'm Per Oscarson. I'm a member of the Business and Real Estate Group here at the firm. I'm joined by Eli Yim, also an attorney in the Business and Real Estate Group, and by Jennifer Takamoto, a paralegal in our Business and Real Estate Group. And our topic today is the dissolution of corporations and LLCs, specifically Washington entities, and as to corporations, specifically profit corporations. We won't deal with dissolution of nonprofit corporations today. So Eli, if you could get us to that first screen, and we'll kind of get started on causes of dissolution. There's really, you can have voluntary and involuntary dissolutions, and then how those happen varies. So for example, we start with the first one, by initial directors without shareholder approval. This is a voluntary form of dissolution of the corporation, but it's limited circumstances in which that can happen. The first one is that the corporation has not issued any shares. Then the directors can vote to approve a dissolution. They may not have issued shares for a number of reasons. Maybe the corporation was set up for a specific purpose, and now they've decided, that's not going to work. We're just not going to go ahead with it. The second situation in which it can occur is if the corporation is unable to pay its debts or its liabilities as they come due in the ordinary course of business, or they are insolvent. If the corporation is insolvent, then the directors can elect to dissolve the corporation. They give 10 days notice to the shareholders that this is what they're going to do, and then they can still go ahead and do it. The second option there is by directors with shareholder approval, and that's pretty much any other form of voluntary dissolution. It could be for any reason. They just decided they don't want to continue. Maybe they can't continue. It could be any number of reasons. And then there's a process that the corporation must follow. It's typical of other, what I would think of as big events in the life of a corporation, a merger or a sale of assets, for example. The directors would get together in a meeting and approve a resolution to dissolve the corporation. They would then submit that with a recommendation to the shareholders that the shareholders then approve. And then at a meeting of the shareholders would then vote whether or not to approve dissolution, and then that would continue the process. It normally requires a 2/3 shareholder approval in order to dissolve the corporation. Again, it's a broad number of reasons that could lead a board of directors to conclude that the corporation should be dissolved. Another way that a corporation can get dissolved is by judicial dissolution, and there are basically 4 ways that can happen. One is a proceeding by the Washington Attorney General to dissolve the corporation. And that could happen because maybe the Attorney General has determined that the corporation obtained its articles of incorporation through fraud, or that the corporation continues to exceed or abuse its authority that's conferred upon it by law. Shareholders can cause a judicial dissolution of the corporation under the circumstances where, for example, the board of directors may be deadlocked in making a decision, and the shareholders may be unable to break that deadlock, and the existence of that deadlock is causing irreparable injury to the corporation, or it's either threatened or is causing, or the business and affairs of the corporation cannot be completed or cannot be operated because of the deadlock. Or maybe the directors have acted illegally, or are acting illegally, or threatened to act illegally, or something they're doing is oppressive or fraudulent. Another reason for a judicial dissolution may be that the shareholders are deadlocked in their voting power, and they have failed for a period of 2 consecutive annual meetings to elect any directors whose terms may have expired. Remember that with directors, they continue to serve, until their successors are elected and qualified. So just the mere fact that a director's term of office has expired does not mean that they are done and no longer serving as a director. It may be possible that the corporation's assets are being wasted or misapplied in the operation, and the shareholders want that stopped. Doing it judicially may be the only way to do that. Or maybe the corporation has just ceased to engage in any activity, and they can't get any further on actually dissolving voluntarily. A third way that judicial dissolution can occur is through a creditor proceeding. This is where a creditor may have gotten a judgment against the corporation. They tried to execute on that judgment. The judgment was not satisfied, and maybe the corporation is also unable to pay its liabilities as they become due or is insolvent. Or maybe the corporation has admitted in writing that the creditor has a valid claim and the corporation just can't pay it. Finally, and this one I think happens pretty irregularly, that is where the corporation itself there may have been a voluntary dissolution commenced, but for some reason it's just not proceeding. So the corporation could actually ask a superior court to step in to assume control over that dissolution process, and then it would continue under the authority of the court. The final way is an administrative dissolution, and this is a dissolution that occurs by the Washington Secretary of State. Corporations are required to file an annual report and pay an annual fee to the Secretary of State. If they don't do that by the deadline, and the deadline will vary from corporation to corporation, usually depending upon when during the year they were formed, they will receive a friendly reminder from the Secretary of State's office that we haven't received your annual report, or we received your annual report, maybe it's incomplete, or maybe they just didn't receive the annual fee. So the corporation receives a 60-day notice from the Secretary of State's office to correct the problem, or respond to say, Secretary of State's office, you're incorrect, there is no problem, and here's why there is no problem. So if the corporation does not respond within those 60 days, then the Secretary of State's office can administratively dissolve them, and they will normally do that within a couple of months even after the 60-day period runs. Sometimes it's possible too that if the annual report has not been filed within 120 days of its due date, same kind of notice could come out. Or if the corporation has not maintained a registered agent in the state of Washington for a period of only 30 days, the Secretary of State's office can administratively dissolve, because by law, corporation is required to have a registered agent and a registered office in the state of Washington. And then finally, although I don't think this happens all that frequently, because most corporations are set up for perpetual existence, if the corporation is set up for a specific period of time, say 20 years, if the corporation has gotten to that 20-year period, and that period has expired, and the corporation has not amended its articles of incorporation to extend the term, then the Secretary of State's office will send the same notice, and it could administratively dissolve the corporation. So I'm going to pass things along to Eli to deal with causes of dissolution for LLCs, or limited liability companies. Eli?
Yeah, thanks, Per. I think most people know at this point that a lot of the entities we're seeing formed these days in Washington are LLCs. They've become very popular. People who form LLCs have liability protection. There's flexibility from a tax standpoint and from an operational standpoint. And I think people find them a little more understandable. Certainly, even in this process that we're talking about today with dissolution, things seem a little more streamlined than maybe on the corporate side. I think in general, there are some similarities. Instead of directors, we're talking about managers. Instead of shareholders, we may be talking about members. But we're really looking at an entirely different section of the Revised Code of Washington, different statutes that are specific to LLCs. And so let's see here. So these are the scenarios in which the LLC becomes dissolved. And there's 6 that are enumerated in the statute, which is section 2515. First one is where there's a date in the certificate of formation, a date certain, at which point the entity will become dissolved. A lot of the things we see nowadays are upon formation are set for perpetual existence. So this does not come up very often in newer LLCs, but that is one scenario in which you could see a dissolution. Some events specified in the LLC agreement could be something as broad as, upon the sale of all or substantially all of the assets of the company, or it could be something much more targeted than that. But the LLC agreement, we know upon formation, we've got the certificate of formation, and then, in a lot of cases, we aim to have a very good LLC agreement or operating agreement in place that kind of governs, the state sets forth how the LLC will be governed. And within that, there could be events specified as those that might trigger a dissolution. Revocation, I'm not sure why if revocation is right necessarily here. I guess we're talking about the written consent of all the members. So all the members can agree that they elect to voluntarily dissolve the corporation, the LLC, and upon written consent, they can start the process of dissolution and winding up. 90 days after the dissociation of the last member, believe it or not, that does occur. We have had situations where the last member has become dissociated either by death or disability. And at that point, the personal representative, in the case of death, would have 90 days to, as a transferee, attempt to elect a new member and continue the LLC. But if they fail to do so within those 90 days, the LLC is determined to be dissolved.
Eli, I think it's a little interesting too that, at least in this respect, it's different from the corporation, because if the last shareholder dies, and I realize, they're both limited liability entities,
Yep.
and you've got ownership interests, but with a corporation, if the last shareholder were to die, then you would think that it ought to work the same way, because that share the shares of that last shareholder may not have been transferred anywhere. But effectively it's treated as, the personal representative having them. And so there's not the similar provision for the corporations as there is for the LLCs on this aspect or potential reason for dissolution.
Yeah, it's really interesting. I mean, you can imagine how quickly that 90 days passes too.
Yes.
In an event of dissociation, it doesn't take very long to have 3 months go by, and then finally people take a look at the LLC agreement or realize that there's no other member. They haven't even thought about it, and next thing you know, they're out of luck and there's no remaining member. And then by statute, then the LLC is dissolved. The fifth scenario here is judicial dissolution. So members can seek an order from the court, a decree that says that the LLC has been dissolved. I think what's interesting here is the language of the statute. You can seek judicial dissolution when it's no longer, I think the exact terminology is reasonably practicable to carry on the activities in conformity with the certificate of formation or the LLC agreement. What's interesting about that is we often see, and I know Jennifer and Per have seen this in LLC agreements through the years, language where the purpose of the LLC is stated as for any lawful activity. Well, if the stated purpose of the LLC is any lawful activity, something that broad, it is quite a hill to climb to convince a court that it's no longer reasonably practicable to carry on activities. And so the idea being that particularly when it comes to the LLC agreement, there's an opportunity there to state the purpose of the LLC with some specificity. And it's good practice in general, but particularly when it comes to judicial dissolution, I think it makes good sense where you can be specific about, for example, to own and operate X restaurant, or that if that purpose is no longer reasonably practicable, then you could seek judicial dissolution if needed. A member could. And then finally, administrative dissolution. I know we'll get into some of the timelines later here, but we see this happen quite a bit. LLCs are required to file annual reports, and the most frequent thing we see here is if you fail to do so, if you fail to file your annual report within 120 days, the Secretary of State will administratively dissolve your LLC. And so the language of the statute here, it does say the LLC is dissolved in these circumstances, and the affairs must be wound up. So these are the 6 scenarios that are contemplated by the statute. And then it's interesting because then it says after dissolution occurs under this section, the first to occur of any of these things, then the LLC may file a certificate of dissolution. So technically, under the verbiage of the statute, the LLC is dissolved, and then you may proceed to file certificate of dissolution. Just interesting the way that's kind of framed.
Because it does differ from the corporate, which requires you to file the articles of dissolution in order for the dissolution to be effective. But you're right, the LLC statute just says if one of these things happens,
right,
whether or not you file a certificate of dissolution at some point, it's dissolved. It's interesting why the difference may be there.
Yeah, and I should point out this dissolution does not end the entity, and the liability protection remains in place as well. So we're talking about these scenarios, but we'll continue, I think, with the next set of slides here to get into kind of the winding up process.
So with the corporations, as well as with LLCs, as Eli says, the entity continues even though it has been dissolved. There's really important, though, that the entity not continue to try to do any business. The only activities they're allowed by law to do are those that are necessary to the winding up of the affairs of the business. And one of those is at least for corporations, getting the revenue clearance certificate. So I'm going to pass that along to Jennifer because she's had quite a bit of experience in getting those and finding out what's the process and how long does it typically take. Jennifer?
Yeah, before you can file articles of dissolution for a corporation, you have to obtain a revenue clearance certificate from the Department of Revenue. It is just a form to fill out. The only hiccup I frequently see is that all of your taxes need to be filed and paid through that last date of business, or the Department of Revenue will not issue you the certificate. And the Secretary of State will not let you file articles of dissolution without this certificate. So actually the form itself is not comprehensive. It's done on a first come, first served basis. I find generally they're going to take 5 days-ish, but depending on their workload, because it is first come, first served.
But you're still finding now that it's still about 5 days from the filing of that request for that certificate?
Yes, it is general. I will say I always follow up with a phone call, Department of Revenue. This is a form that gets filled out and gets emailed to them. And then I always follow up to make sure that they've received it, because I have had some where I have not heard back in that time frame, thought they were just overloaded, but really it somehow got lost in transmission. So I would always follow up with a quick phone call.
Mm-hmm. Okay. So then continuing though with the dissolution process for the corporation, files assuming it's gotten the revenue clearance certificate, files articles of dissolution with the Secretary of State. The statute requires that the notice of the dissolution then be published in a legal newspaper in the county where the principal office of the corporation is located. And then you can start to deal with known claims. And there is a process laid out by statute that allows the corporation that's dissolved to deal with the known claims and potentially bar claims that are not asserted. The statute requires that you have to have at least 120 days from the date of notice for the creditor to respond to this notice of dissolution and file their claim and give them instruction on what information to include, where to send it, what the deadline is, all of that. And the creditor can be barred from asserting their claim, even if the statutory statute of limitations has not run. They could be barred from continuing to assert their claim if they don't file this claim usually with the corporation by the time of that deadline. Now, it's not as easy to deal with unknown claims, but hopefully a corporation knows the claims that are out there and can address them. And of course, the creditor's claims, to the extent that they are valid, they get paid first. And then there's another hierarchy of distribution of whatever remaining assets there are. So why don't we move to winding up of an LLC, which similar process, but I'll defer to Eli on that one.
Yeah, it's really important, and this is all laid out by statute as well, and pretty similar. And I think in a lot of our guidance to clients who are winding up LLCs, we tend to mirror kind of the procedure that you would follow for a corporation, just as good practice. You know, I think most of the time we will coordinate with our clients to proceed with winding up and draft a plan of liquidation. In that plan, the members would acknowledge the consent to dissolve the LLC. We also then would list out any known liabilities and work with our clients to get notice out to those known creditors to file claims. Again, I think similarly, there was 120 days for those creditors to file a claim with the LLC. And if it's not received within that time, then it can be time barred. We actually, even though it's not required in the LLC statute, often recommend that our clients go the publishing route as well, just for no other reason than to get word out there of the dissolution and provide some extra protection against any other claims that may come in that are untimely. If the LLC, however, receives the claim from a creditor within the 120 days and then rejects it, the creditor has 90 days after that to commence an action to enforce their known claim. And so that's all spelled out in the statute. Also, I think within that plan of liquidation, there's the liability piece. There's also the asset piece. This is where we would walk through kind of gathering all the assets. You know, maybe there's some additional AR or accounts receivable that's coming in, or, you know, as you're winding up, there may be refunds or a return of maybe some prepaid expenses that would come in. Those all kind of get aggregated. And then I think from that point forward, you would then proceed to pay out the claims. And so the distribution of assets would be, you know, first to the creditors, then to maybe some of the members for any specific distribution reasons. However, there would be agreements with members for special kind of distributions. And then the return of the contribution to the LLC and pro rata distribution. So that's kind of the order of distributing some of the assets, so the assets of the company. I think also within those plans of liquidation, we generally will include some release language where members are released by the other members and by the company, provided that everything has been kind of followed as prescribed. It gives that additional kind of peace of mind, I think, as you proceed with dissolution and winding up. And the other thing I think that people come to see as they work through this process is there may be a bit of a tail on things. So, for example, you may have to keep an account open with some assets just because you'll have to pay taxes the following year, for example. But all of that kind of gets sorted out in this process. And I think people get a sense of the timeline laid out the way we kind of walk through it with them. And so that's kind of our process winding up. And I think what Per said, same thing here with LLCs as on the corporate side, which is the purpose of the entity at this point is for the purpose of winding up, right? That the LLC remains
Right.
active for the purposes of winding up. And so this becomes the focus of the LLC at this point, following dissolution.
Yeah. Jennifer, I wanted to ask you, we talked about with the corporations, there's the revenue clearance certificate that's required in order to file the articles of dissolution. With a limited liability company, is there a similar certificate that's issued?
No, there is not.
No, and no other process to deal with those kind of tax issues that could face an LLC, just like they could a corporation, that they may not have paid all their taxes, but they're still not required to get a certificate like that. And there apparently is no provision that requires the issuance of such a certificate for an LLC.
Interestingly, no.
I've always found that to be kind of unusual.
Yes.
Well, I know we had put this slide in here, and I wasn't sure, Jennifer, was this where we were planning to have you walk through some of the
Yeah,
processes?
I'm happy to talk about that. So we, we would file logistically, you're going to file articles of dissolution for a corporation. For an LLC, you're going to file a certificate of dissolution. The common issue I see here is that the Secretary of State has administratively dissolved your entity for failure to file an annual report. And the Secretary of State will not allow you to file either of these unless you are reinstated. So you need to go and pay that fee to reinstate yourself. Then you can go in and dissolve. And by dissolve, I mean file the articles of dissolution or the certificate of dissolution, whatever your case may be.
And I think it's also interesting that I think under both corporations and LLCs, that process for dealing with known claims is only available if you have voluntarily dissolved, not if you're administratively dissolved, because it all ties to, with corporations, it ties to the publication of the notice of dissolution, and which means that you have filed articles of dissolution. And with the LLCs, the mere filing of the certificate of dissolution is kind of the trigger for being able to use that known claims process.
Correct, yes.
So it is kind of interesting that it changes you from administratively dissolved to, for what may be a very short period of time, an active entity that now voluntarily dissolves.
Correct.
Probably in order to use the known claims resolution process.
Mm-hmm.
Yeah, and I think I should say under the statute too, right? If you do file the certificate of dissolution, so a claim against the dissolved LLC is barred if the LLC has filed a certificate of dissolution and not revoked it, and the action is not commenced within 3 years. So
Right.
Filing the certificate certainly has an effect as opposed to not.
Yeah.
Right, and it is it isn't an expensive filing, I will say, in Washington for either one of these.
No, that brings up an interesting point, Jennifer. I know we deal with entities in a number of other states.
Yes.
How do some of those states compare as far as cost to dissolve? At least the filing fees with the state.
It varies quite a bit from state to state, the fees, because also some of them, California, for example, you also have to have a similar tax certificate, but that's an expensive, they charge about $800 a year. So that's going to be a more expensive process in different states. Some are similar to ours also, but yeah, it does vary quite a bit.
Okay. Well, I didn't see if we had any questions. I think we've covered what we planned to cover. And I don't know that we have any questions from the audience.
No, but if people do have questions, we've got here on the slide our contact information. And so, yeah, absolutely. If you find yourself watching this, whether live or on videotape, I guess they don't use tape anymore, but or streaming it, feel free to reach out to us with any questions you may have. We're here to help and would be happy to do so.
Yeah. Well, thank you for joining us this week. Next week, the firm's litigation group will be presenting a webinar on Thursday, June 30th at 12:15. Thanks again for being here.
Thank you.
Thank you.